Kia ora, everyone. Morena. We're just waiting for more people to trickle in to the webinar. We're just waiting for a few more registrants to pop on, and then we'll kick off from there. All right. So, like I said, we are slowly waiting for people to jump onto the link. But I thought while we're here, I'll just have a chat to you guys, see how everyone's doing. Feel free to drop any comments if you want in the Q&A box so that we can always see how everyone's tracking along. We are nearing the end of the year. It is finally here, everyone. We are finally making it towards the end. Very exciting stuff. And there is definitely a lot moving in the space from what we can see for next year. So this year, it's good to know that employment law has slowed down a little bit in New Zealand, but next year, definitely, we are seeing the pace continuing, and it'll be interesting to see what laws come out. So in terms of, I guess, kicking things off and seeing where everyone's at, I'll give it a couple of more minutes and then I'll wait for a few more people to jump on and then we'll go from there. If you're here hanging around, I know our wonderful event specialist in New Zealand, Bernie, she's hanging out back, fielding a lot of questions that might be coming through, also letting you guys in. If you're jumping in, I know you've been there for a little while, go ahead, grab a nice drink, a bevy, and take a seat and enjoy, because today we're going to get into a few nitty-gritty bits and pieces here and there when it comes to the changes for next year. So definitely take some time, go and get a drink. Speaking of drinks, actually, I was thinking about, I live very close to the Wairarapa region, and I was thinking about going to Toast Martinborough. So if anybody has been there, feel free to use the Q&A box and let me know. And if you are going to be there, then I might see you there in January next year. So very exciting stuff. So I'll just give it another minute and then I'll kick things off. So like I said, feel free, go grab a drink, hang around, see what's going on, and then we'll kick things off shortly. And I really hope that that everyone is feeling geared up to finish the year strong, and then we'll tackle all the big employment law things for next year, I'm sure. So I'll give it one more minute. I know that I'm dragging this one out, but I just want to make sure that everybody's there and they're all happy and actually on the call, and then we'll kick things off from there. So just give it another minute and then we'll go. So yeah, like I said, if any of you have been to Toast Martinborough, please let me know. I would love to see what's going on, because I definitely want to go and visit. Like I said, I only live like an hour away from the Wairarapa region, so it'll be a good event to go to. Lots of music, lots of fun, and of course the wine. So, so yeah. Well, I can see that a lot of people have joined on, so I just wanted to say welcome everyone. Kia ora. It is so great to have you all for this webinar. It is amazing to have you here this morning. Thank you for taking your time out. Welcome to this webinar on New Zealand employment law wrap up for next year. We are going to be looking at a lot of things coming out, but this year I wanted to wrap things up. I was so excited when our event specialist Bernie reached out, because I said we've got a lot to cover to gear businesses up for next year, and I am so excited to be talking about that today. So you may be wondering who's speaking. Well, my name is Sanam. I am the Employment Counsel here at Employment Hero. This is my lovely photo. Clearly, I don't look like that all the time, so now you know. But I work as the Employment Counsel here. It's a glorified name for an in-house employment lawyer, and I am all about making sure that our regional tech is all on par with the employment laws and the requirements. Also, while people are trickling on, I'll give you a little bit of background about me. I am an employment lawyer through and through. I have worked across different industries, different businesses. I've worked in-house, private practice, and I've seen it all from what SMEs deal with all the way through to large corporates and large businesses. And with everything that I've seen in my time, I also realized very quickly that a lot of employers need help with their compliance and understanding the requirements. So I started my own podcast, which you can absolutely go and check out. It's called Lawlands, Employment Law Done Right, and it will definitely give you the tips and tricks and insights that you need to make sure that you're compliant and you stay on the right side of the law, which everyone loves to do. So I will just do a little bit of housekeeping while we're kicking things off and getting things done. I wanted to say that we've allocated time for your questions at the end of the session. So absolutely make sure that you use that Q&A box down below, you type in whatever you've got to, and that you have any burning questions sent through to us so that we can get to as many as possible towards the end. I may be a little bit darting here and there, and I do apologize for that. It is only because of the fact that I've got a few things happening at the same time, you know, the slides and then also what we're going to be running through, and we'll have polls as well. So I'd love for you to participate in that. Now, when it comes to a quick disclaimer, I just wanted to say that, look, these are the views that are presented by us and they're presented to you in good faith. If you are dealing with anything in particular, then I always recommend that you go out and get specific expert advice that you may need for your tailored situation. The great thing about today's webinar is that we will be talking about our HR advisory service. So stick around till the end, because this may be the service that is just for you, that can help you get out of those sticky situations when you're dealing with employment law. So to talk about today's agenda, I wanted to go through a quick, brief reflection of what we've discussed in 2024. If you've attended our webinars in the past, then you would know that we've covered quite a few topics. So I just wanted to do a quick overview. And then from there, I wanted to go into the key changes that we're going to potentially see, fingers crossed, next year, or maybe the year after, depending on how long it's taking with the coalition government doing their consultations and all their draft bills and everything. But that will be specifically related to the Holidays Act, as well as the upcoming changes around contractors and the gateway test, and also looking at the health and safety regulation changes as well. And like I said, an exciting wrap up to talk about the HR advisory service that we have brought into place for New Zealand. So absolutely, like I said, type in your questions, put them down at the bottom of your Zoom screens, and we'll have that live Q&A after I finish off this presentation. So let's kick things off by taking a look at a quick reflection for what's happened in New Zealand this year. Now, it's really interesting because we've seen a lot of the change, like the space change. We've seen fair pay agreements get scrapped effectively, and that was at the tail end of 2023. And I moved it into this year because technically, you know, we saw it right before Christmas. So everyone was enjoying their presents and their gifts, and all of a sudden, you know, we had all of these changes that came into place. But what I can say is that it's been a welcome change for a lot of businesses out there. The 90-day trial period has been brought in for all businesses. And again, that has been a welcome change as well for a lot of employers out there that are larger businesses that really wanted to utilize the trial period. And then you also have the introduction of worker exploitation legislation. Now, without going into too much detail around this, I do want to say that the couple of things that really came out of this, which I found the most interesting, and I've already spoken about it before, was the fact that you now have a 10-day period that you need to hand over documents if you ever have a labor inspectorate giving you a request, or if you have an immigration officer coming in and asking for details. So you now have a 10-day time frame. Now, more than ever, is compliance really important for your business, because if you ever have a random labor inspectorate audit, an audit by an immigration officer, or anything of that sort, then you have a very tight time frame to work with now. And it's not like before where the leniency was there and you could kind of take a little bit of time, maybe not delay, but, you know, drag it out slightly. So it's a very different environment that we're in now. So with that said, I would definitely say that, you know, minimum wage increase, we definitely know about that, but with the increase in compensation bands, that's very critical as well. One of the areas that we do kind of discuss when a personal grievance comes up is compensation. If you've ever dealt with one, I am so sorry. I know how difficult it can be to work through that. And I'm sure that if you looked at settling, compensation for hurt, humiliation, and distress was one of the remedies that was proposed. And unfortunately, what we're seeing now is that these bands and these amounts are going up in terms of how much an employer will have to pay to settle a dispute, or if they go all the way to the Employment Relations Authority or further, then there has been guidelines now on how much more the employer will need to pay as that goes. But obviously, it's very circumstantial, very based on your situation. So absolutely make sure that you check out our previous webinar on this as well. And removal of 90-day trial periods for accredited employer work visa. I actually wanted to squeeze this one in there. I know I might have mentioned it briefly before, but the reason why I wanted to put this in there is actually I went through and I had a look and I saw that people have been asking this question still. So yes, yes, absolutely, that has been scrapped. You cannot have a 90-day trial period in there. In terms of a probation period, I don't see any issue with that. There hasn't been any mention of that, but keep in mind that the probation period does require you to have a separate set of processes and things that you need to undertake to be able to terminate an employee. The last thing, without me getting into too much detail, definitely if you're in this space, you would know that the accredited employer work visa requirements have changed significantly. The change has been drastic in terms of having English language testing all the way through to the ability, the lack of ability to stay in New Zealand and having to actually go back and reapply to then come back. There's been a lot of change in that space. And if you're in that space, and I would definitely suggest that you reach out, that you speak to somebody in immigration, because it is complicated and it's only going to get more complicated as the years progress. So that's a bit of a quick reflection and a wrap up of that area. Now, I wanted to get into something a little bit more nitty gritty, which is looking at the Holidays Act changes. Now, these have been, trust me, I am here, I hear you. This has been done to death, I know, and I still am so glad that you came and joined this webinar, because it is one of those areas that we have spoken about since like 2018 or something. The task force for the Holidays Act was put together. There was all this conversation and all this interest that drummed up, even so much so that I actually went back. I was on YouTube yesterday, checking out some of our previous webinars, making sure that I had covered off some of the topics. And I clicked on one that we had done in 2022. And I wasn't a part of this one, but I heard them discussing and saying very, very adamantly, very vehemently, that these changes are coming into place. Employers need to prepare and watch out and do all of these things, because at that time, there was so much conversation that these changes would happen within the next few months. But we've always seen a bit of pushback and reluctance to get this in place until we get this right. So under the Labour government, we definitely saw that this was in discussions, the task force got together, but now with the coalition government, we are looking at a different situation. There's been targeted consultations that have happened, and they commenced and kicked off in September. Those consultations were basically looking at those 22 recommendations that the task force put together. And then now it's just a matter of seeing what people are vibing with, what people think is okay. What is payroll thinking? I know we definitely partner up with NZPPA. And one of the things that they always are involved in is these kinds of changes to the Holidays Act or any space when it comes to payroll, because that is their main focus with getting New Zealand on track when it comes to payroll. So definitely, we've seen this space change. Now, there has been indication that there will be a draft bill being sent out in December, but I wouldn't hold your breath, because there has been a bit of back and forth that I've seen online from the minister, from other news outlets and things like that, saying that there might be delays with this. If you think about it, the coalition government is talking about Holidays Act changes, contractor changes, Employment Relations Act changes. There's a lot on their radar. So to say that this will be the first cab off the rank and this is the first thing that will be fixed, I don't know. I wish I could predict these things for you to make it a lot easier, but we'll see how it kind of goes. So I won't go through all 22 recommendations. As you can imagine, this would be a few hours worth of a webinar, and I don't want to make you sit through my screechy voice talking about that. But what I will cover is some of the key areas that I thought would impact a lot of businesses across Aotearoa. And the first one was dealing with accruing annual leave. Now, technically, right now, an employee actually accrues leave, and a lot of times what we say is that it's accrued leave. But under the legislation, there is no wording or terminology around accruing leave. It actually says that you're giving an employee leave in advance. You might ask why? It's because they're not actually entitled to it. The way that I look at it is that, let's say you give your employee a beautiful cake. I would love a cake. If anyone's listening on this call, Bernie, you know who to send it to. If you give your employee a cake, you would cut that into slices. And what we say is accruing leave is that you'd give them piece by piece, right? And eventually at the end of 12 months, after you've given them all the pieces, you should have an entire cake that they're sitting there with. And then finally, at that moment, they are able to eat that cake. But what we do usually, and it's very common amongst a lot of employers, is to actually allow employees to take bits of that cake and eat it along the way of that 12 months. And so that's essentially where the law is at the moment. assessment. Now, that's quite confusing because it doesn't work with general practice. It doesn't work with a lot of things that people are doing in their workplaces. So that's why the 4-week annual leave entitlement will happen continuously, and it will accrue properly at about 0.078 weeks per week. And that's how the proposal has come out. So these are the changes that they're proposing. And when it comes to calculating annual leave, we know how difficult this can be. What if somebody works variable hours? And that's another area that's going to be changed as well. We're going from currently average weekly earnings or ordinary weekly pay, looking at the greater of those two, to now moving to a different model. And if you have somebody that's, you're trying to give them 4 weeks leave, what if they work variable hours? What's the shift got to be towards? This is where the proposal from the task force that's now been accepted, and obviously we're waiting, consultation's been happening. There has been the introduction of a new methodology. The new methodology will be a greater of 3 rather than the greater of 2 approach. One will be the ordinary leave pay, which is up there on the screen, and that will be around what an employee would have earned if they were at work at that time. Then you'd also have, and this is the new one that kicks in, average weekly earnings over 13 weeks, and then average weekly earnings over 52 weeks. Why? Because some people, they have variable hours. You might go back 52 weeks and it wouldn't be as fair as going back 13 weeks, for example. So that's the justification there when it comes to the Holidays Act and what's changing around calculating leave. Now, pay as you go. Look, I know if you've had somebody that's been a casual, if they've been on a fixed term, I know all of you out there that might be nodding, then there is so much confusion around what intermittent and irregular actually means. There's so many times that I have seen employers saying, can I just give them the 8% they really want, the PAYG? Why can't I give them this? And it's tricky, right? It's really difficult because the law is broad, it's confusing, it doesn't have the clear information in there. So that's why this definition is definitely needing to change, and it's great that they've picked this up. So there will be, according to the proposal, a clearer definition of what intermittent and irregular means. There will also be an objective criteria that you can use, which will allow you to stop having to use your own judgment and establish whether this person is eligible for PAYG or not. And then you also will have the ability to go back and check in and see if they're supposed to be getting that 8% pay as you go or not. And the reason why that is because a lot of times when you have somebody like on a fixed term, it's set and forget, right? You end up setting it in place and then you go on from there. But in this particular case, we're looking at a situation where it's, let's go back 13 weeks, let's have a look and let's see if they're actually eligible after we've done that assessment. And the last thing that I wanted to cover off, which I think is quite timely as well, because I'm sure a lot of you are all going through this, close downs. Now, I don't know if any of you know this, and I hope some of you do. And if you do, then definitely a massive tick to you, gold star, because this is one thing that no one speaks about at all. And it is the fact that the law is really, really clear on the fact that if an employee is not yet entitled to leave, let's say that they've just started working for you a few months ago and you're doing a close down period, then you actually need to pay them out 8% of their earnings at the point at which they go on their close down break. A lot of times people don't talk about this. It's not commonly done. And there's also a lot of uncertainty that's associated with it. And a lot of employers just allow employees to take leave in advance. But the law is actually really clear. The Holidays Act is very clear in the fact that you need to actually pay out your employees. So many don't do this, like I said. And the whole idea behind the change when it comes to close downs is that there is going to be greater clarity, transparency around how employees are actually notified about close downs and how they need to take their leave. So there will be no more leave in advance requirements or anything like that. And there will be a shift that we'll see in that space as well. So definitely keep an eye out and keep in mind as well, we are going to be running a poll after this bit, and I want you definitely to participate because I want to know what you're going through. Next year, we want to hit the ground running when these changes are at a draft bill stage or even when they're fully enacted. Hopefully, if we can get things over the line, then it will be great to hear your thoughts because we definitely want to put out a webinar around that. So what I'll do is I'll go into family violence, bereavement, sick leave, public holidays, alternative days, all of that area. And it's an interesting one because we can see that the Holidays Act is changing to allow for a bit more broadening. There's definitely a lot more discussion around, what will work with situations where it's not a 9 to 5. A lot of us that are sitting on this call would be going, yep, the act is tricky because it's really meant for a 9 to 5 employee. The reality is the agricultural industry, our horticulture industry, our hospo industry, all the larger industries that we have, construction, all of that, they don't operate 9 to 5, and that's the reality. And so we need the laws to kind of catch up with that. So when we're looking at the family violence, bereavement, alternative public holidays, and sick leave, FBAPS is what they've abbreviated it to. Very, very hard to do FBAPS. So I think I'll keep it simple and target each one. So when we're looking at the calculation that's being brought into place, what exists at the moment is that you look at the greater of relevant daily pay or average daily pay over 52 weeks, right? That can be a bit confusing, variable hours. So that's why they are looking at changing the methodology, changing the structure, and making it the greater of either ordinary leave pay or average daily pay over the last 13 weeks. So again, that 13-week number seems to be the reoccurring number that's coming up for these calculations to make it a bit easier to understand and a little bit more applicable to those businesses that have variable hours. Now, when it comes to how leave is taken, something that the Act does not specify is that sick leave and other types of leave should be taken in part days. A lot of times I've noticed employers doing this, and they're doing it because sometimes, hey, I might want to go jot out to the doctors and maybe just take an hour or two off of work rather than blowing through 8 hours of a day. And as much as I would love that, your sick leave finishes very quickly. So sometimes you want a shorter period of time. And this is what this change will allow. It will allow for employees to be able to take at a minimum a quarter of a day of sick leave, and it will allow them to take units of sick leave rather than taking an entire day, or employers pushing the boundaries and allowing for that, but feeling really uncomfortable with the fact that this is not actually within the parameters of the law. There's a lot in the Holidays Act that I feel like employers do out of good faith, out of being kind to their employees, but it's not compliant. And that's unfortunate because it puts you in a detrimental position for actually effectively being nice and kind. So it'll be good to step away from that as well. Now, eligibility is another interesting one. Currently, when you're dealing with bereavement leave, family violence leave, sick leave, you have to wait 6 months for eligibility. Family violence, bereavement, and sick leave will become a day one right. That will be a really, really interesting change to see. And the way that it will become a day one right for sick leave is that it might slowly accrue over time. And I believe that the numbers that have been thrown out, and look, there's been a lot of misinformation in the space, a lot of different people speaking about it, but the general consensus seems to be that it will become a day one right, and it will accrue in some respect. So maybe 2 days a month, and for the first month, and then from there after 3 months it will accrue a few more days, and then a few more days a couple of months later. So that's how it will generally work, rather than giving a lump sum amount to an employee. Now, that was just for sick leave. When it comes to bereavement leave and family violence leave, that will definitely be a day one right as well, but I believe that you'll get the entire entitlement once you become eligible and you get that day one right. Now, when it comes to bereavement leave, there is a lot of interesting talk and discussion out there. I know on the podcast recently, I spoke about the curly side of bereavement leave, because what happens when you're looking at bereavement that's not for an immediate family member? At the moment, the legislation is really clear. It wants you to have a look at, the 3-day eligibility, or that 3-day entitlement is for people that have suffered a bereavement relating to somebody close to them, like their partner, or like their parent or grandparent or partner's parent. But what happens when you're in a different cultural scenario and you have a broadening of family? And in that episode, I spoke about, for example, in the Indian community, every auntie every person is considered an auntie, but then sometimes an auntie of further distance could actually be an auntie that raised you in a community with other people. So it always will depend and vary depending on cultural circumstances, and that's where where there's been a discussion to broaden out the scope of bereavement leave to cover different family members and different cultures and different types of communities as well. So I think it will be an interesting shift and an interesting change to see that. One of the things I spoke about in the podcast was about pet bereavement, and whether this is something that people would want brought in. So definitely an interesting area to see unfold. And when we look at otherwise working day, now, it is the bane of everyone's existence, is to figure out someone's otherwise working day. If you're looking at me skeptical or shaking your head, then I'm telling you that you probably work in a 9-to-5 business, because the experience that I've had generally across the board when it comes to hospitality, construction, all of those different areas, people are really finding it hard to figure out otherwise working day. We know that companies like Wendy's, they've tried to do the 4-week test, and that didn't work. They got done for a couple of times for that. We know that a lot of employers will try to go back a couple of months, but then it feels really uncomfortable. What we know is that the definitions are not very clear, that employers have to use their judgment, which is a really tricky situation to be in as somebody that doesn't understand compliance inside and out, that doesn't know what would be the best judgment with conflicting information. So it's a pain when you're trying to figure out otherwise working day. So I'm happy to say that this proposal and what has been accepted to move ahead to the consultation process is that there will be a new method for determining otherwise working day, and also a good parameter that will be put in place to make that happen, so that you can go back, however many weeks, and be able to see that. The amount of times, especially during COVID, I saw it a lot more, where people had taken on a business and that they were saying, does this employee actually get the Monday public holiday, because they've worked Mondays for the last year, but then now with me coming on board, I'm not going to be giving them a Monday. So many scenarios that can come up, so many different things, so many issues. So that's why it'll be a great and welcome change. So I'll keep things moving, keep it very brief for these two, but a couple of things I thought that would be really important for people out there is gross earnings definition. Now, right now, if you're running payroll and somebody goes to you, what's their gross earnings? The definition isn't clear. Sometimes you might be thinking, oh, well, does this extra bonus kind of go in there? Or does a discretionary payment go into gross earnings? What's actually included? And so this is where the definition has clearly needed to change. One thing that I saw in the policy paper that I read when I was putting all of this together was that there has clearly been a point out by the task force to say, hey, look, this is one of the most common litigation issues that are coming up. We need to fix this so that people actually know what they're meant to be getting paid, what their gross earnings are. So there will be a new definition that all cash payments received, except direct reimbursements for costs incurred, will be considered gross earnings, but we'll see how that kind of transpires after the consultation. The last thing is sale and purchase. The reason why I wanted to throw this in there was because I know a lot of businesses, unfortunately, are going through redundancies at the moment. They are looking at selling. Some of them are looking at purchasing. So I just wanted to talk about the fact that there is going to be a shift in this space, quite a significant one when it comes to the employee protection provisions in the legislation. At the moment, in the current legislation as it stands, there is no choice when you are moving from one employer to another, when there's a transfer of business or a sale and purchase, that you get to keep your entitlements, get to move with your entitlements there, or you get them paid out. Now, what the proposal is that the employees will be able to choose whether their entitlements are transferred to the new employer or not. And this is something that they can discuss with the new employer, which gives a lot more power to the employees and allows them to have a lot better and more transparent discussions around this. It is one of the biggest pain points I realize, and it will probably be an interesting change to kind of see where the space goes. Now, I wanted to do a poll, like I said. Do you believe that the Holidays Act changes will make payroll easier, is a question that I wanted to pose to all of you, specifically around, what are you feeling? Because like I said, next year, we definitely want to look at doing a webinar, and we want to make this as amazing for you as possible. And so the question is, do you actually feel that these changes are going to be easier on your business? Do you feel like it's going to be a minefield to work through? And the reason why I actually asked our lovely Bernie to include this was because I did see a lot of discussion online where people are very skeptical. They're saying, these changes might be positive, but they're not going to be ideal. And we need to really get a little bit more information, especially around the calculations, how that's going to work in practice. So like I said, consultation happened in September. We're going to see that wrap up. And then hopefully by December, we'll see a bill. If not, then in the new year is what it's looking at. But it's definitely moving a lot quicker than it did before. But obviously the coalition government has that base that they've worked off of to now progress this further, which is great that this is on their radar. So I'll move on to the next thing, which is actually looking at the gateway test for contractors. I know that I am on a bit of a time crunch now. I've I've done a lot of talking, but bear with me. The gateway test is a really interesting one, and if you are anyone that has had contractors in your business or employed any employees and then they've moved into a contractor kind of situation, then you would know how tricky things can get. We always hear about employee versus contractor. Oh, be careful. Are you sure they're really a contractor? Always a lot of fear around bringing them on. So what we have now is that if you are in a situation where you have a contractor, but they turn around and they raise a claim and they say, look, I'm actually an employee. You've done wrong by me. We have tests in place, but the tests are like a 4-pronged test. You have to go raise the claim, go to the authority, or, like Uber, all the way to the employment courts, and you'll see what unfolds from there and what the decision is around that. It's very hard to make that call beforehand, right? So that's why a lot of employers are very hesitant to bring on contractors, because there's a lot of uncertainty with that. So the process we have right now is that you have four areas or 4 criteria. I should do it this way. 4 criteria that you're going to have a look at. The first one is around intention. And that's all about, did the parties actually enter into this knowing that this was a contractor situation? What's the actual, conversations that were had around that time? The second is around control. So are you actually monitoring them? Because if you're looking at a contractor coming in, I always use this as the most basic example, but it is actually the way that contractors work. If I had a broken window, I know you can't see it, but I have a window next to me. If that was broken, I would call up a company and I would ask them to send over a contractor to come and have a look at the window. I wouldn't be dictating times to them, dictating their hours or anything like that. They would come in, do the job, bring their own tools and go. So the question is, how much control do you actually have over this particular person? A lot of control is no good. That seems similar to an employee. Then you look at integration as the third thing that you need to have a look at. How integral is this contractor to the business? If you're starting to say that without them, we just cannot operate, we cannot do a single thing, then that is a slightly alarming, because usually a contractor would come in, get the job done, do whatever they've got to do and leave. They've got their own business to run and their own things to do. So another question I always bring up as well, and I always ask is, are they involved in your Christmas parties, in your day-to-day huddles and all of that? And if so, why? They're supposed to be a contractor. They're supposed to come in, get the work done and go. And I believe that a lot of times they become integrated in that capacity because you don't want to segregate anyone. Nobody wants to do that. So the last test, or the last criteria of the test, is also looking at the economic reality and looking at whether they have a business, whether they're GST registered, what shows that from an economic perspective that they are their own entity, they are not an employee, they don't have to worry about holiday pay or anything like that. So those are all of the areas, and that actually will allow you to understand the true nature, the actual nature of this particular contractor, the relationship, and what's going on. So you can imagine this is a lot. It's a lot to have to break down. It's a lot to argue back and forth. And that's why cases like Uber, they went all the way through to the courts, to the Court of Appeal. They went through that whole entire rigmarole. So to make things easier, what the coalition government has said, and you would have seen Minister Brooke Van Velden do her announcement if you've kind of been in the space and seeing these things pop up, then what she said was that they want to introduce a new test, a test that's kind of like a pre-test that you would have a look at first before you moved on to looking at integration, control, and economic reality and all of that. So this would be the first port of call. And let's say that you have a contractor, the contractor's kicked up a fuss and they've said, absolutely not, I'm actually an employee. Then this would be the first test that you would need to apply. Now, this is going to be made as changes to the Employment Relations Act. It will be a bill that will be introduced next year. So keep in mind that there is nothing that you need to do at this stage, but hopefully if this gets passed and it goes over the line, then know that you have a lot more certainty for having contractors, and that you also can feel quite secure in the fact that you're treating them correctly and that there is not going to be any peeling back of the entire relationship if you tick these boxes. So these are the go-to, and these would be the key areas that you would need to make sure that you say yes to. So keep in mind, it has to be a yes to all of these. So the first thing is, does a written agreement say that the person is a contractor? So meaning, do you have a written agreement? Does it say that they're a contractor? Then the second part would be, does the business allow the contractor to work for other businesses, including their competitors? I know you might not like it and you don't want to see them jumping over and going over there, but they are a contractor. It's very hard to restrain them to one particular area. I have a bit of concern around this because obviously there's a lot of companies that work with a particular IP and confidentiality and things like that. So it'll be interesting to see how it works in that space, but we'll see as the legislation and the bill kind of unfolds and we find out next year. The third thing that you'd need to consider is, can the contractor work whenever they want? No specific days, no specific times, no specific hours. They get to come in whenever they like. And then the last thing that you need to have a look at is if the contractor doesn't want to take on any additional engagements, so they don't want to do anything else. You've given them their contract. You've said, hey, can you fix this window? They've said, yep, I'll get that done. And then you've said, oh man, I just broke the other one in the room. Could you do that one too? If they say, no, I don't want to do that, then you can't terminate their contract. And if you do that in any capacity, then that would be a no to that particular criteria or that question. So like I said, if there's a no to any of these, then the current test that we have at the moment will be the next step that you need to take. So that will be the go-to. So this will be the pre-test. And this is what the gateway test is. Think of it as a gateway to basically the situation and seeing if the gate can be shut and it can be a done deal, or you'll have to go to the next stage, which would be going through all of that testing around integration, control, all of that. So that is the main key changes with independent contractors. It'll be interesting to see how the space changes. And then the last thing that I actually wanted to get into for employment law updates specifically was around health and safety regulatory system changes. Now, there's been a lot of discussion in the space around this. I actually, to be honest, I didn't realize how severe things were in the health and safety space until I actually got into employment law. Don't worry, I didn't start yesterday. This is something that's been on my radar for a long time, but I wanted to put this into perspective for all of you. So the legislation that we currently have in place is from 2015. So it's not too archaic or anything like that, where it is from 2003, like some pieces of legislation. I'm looking at you, Holidays Act. But we have these pieces of legislation in place, and what we're finding is that it's not mitigating any of the risks, not preventing. And the reason why we're saying that is because the data that's come out from WorkSafe, so I'll give you data from 2022 to 2023. We had 62 fatalities that happened in a year between that period. And these were fatalities that were, deaths on site and things like that. There were 34,887 injuries that happened in the workplace. And this meant that approximately these employees would have to be off for more than a week of work at a time. So that's 34,000, almost 35,000 people that were off of work for more than a week because of a workplace-related injury. And then the last thing, which I found the most alarming, was health-related deaths in the workplace. And I'm talking about scenarios where maybe people are not given the correct PPE, or there's prolonged sickness that gets caused in the workplace. 750 to 900 per year is the estimated amount of health-related deaths. So it is really, really serious what we're seeing in this space. And that is why there has been a lot of discussion by the coalition government to change the health and safety regulation. Their aim is basically to make it more clear, more effective. They want it to balance out the risk that that you're actually experiencing compared to what you need to do to minimize, mitigate, and eliminate those risks. So they're trying to make things a lot easier. So balancing that risk with cost factors. Now, the consultation submission closed on the 31st of October, and that was at 5 p.m. I haven't seen anything come out yet, although I didn't check this morning. I did check last night and I didn't see anything anything get updated. I did have Bernie messaging me going, has there been any changes? And I said, no, nothing yet. So we'll have to kind of see where it goes. I'm expecting that they're wading through all of the documents and all of the information and everything, and that's what's taking a little bit of time. But the last bit that I wanted to get through was actually some things that you can implement and move ahead with. Look, I can go through these questions that are here around what they've asked as part of the consultation, but these are things that you can always walk away with and have a look at afterwards when we send out the information for the webinar. But these were the areas, and I wanted to leave them with you so that you kind of understood where the consultation was in terms of what people were asking. So the last thing was around your health and safety regulations. Now, I wanted to give you a bit of a reminder for right now on what you can do practically for your business. And it's more just to sit back, and sometimes just reflecting on your practices could make a huge change for your business. So if you have a high risk business or even a medium risk business, maybe you're in an office-based environment and you've not even considered health and safety. Before I left to come to Employment Hero, I used to work in private practice, and I was absolutely the person that was, full throttle health and safety. I was the health and safety representative. It wasn't by choice, but I'm so glad I did it because it really did open up my eyes to that whole area of health and safety. And it's really important that you review your current health and safety frameworks. You have a look at what you've got in place. You understand what your risks and hazards are, and you have people that are trained to identify this. Something as simple as being in an office and having a trip hazard, or I saw a junior law clerk picking up something from one of the top shelves, and there was a huge box filled with files that basically was like, missed a near miss. So all of those things are really, really critical and important to understand in the workplace and to have people to spot that. Now, PPE is key. Like I said, we've had that number of 700 to 900 people worth of deaths that can happen in the workplace, all health related, prolonged health issues. PPE is really important. So making sure that you give these to your employees, making sure that you do your PPE reviews. I know my partner recently, or I think last year, the factory that he works in, they have to wear their steel cap boots and all of that, and they actually tried to dabble in a new company and a new brand, and the boots were extremely slippery because they work with confectionery. So it just depends, and it's really important to trial things out, see what works for the team. A lot of times a team will kick back about particular types of PPE, so make sure that you've got the right things in place that protects them and also makes them feel comfortable in the workplace. Now, the other thing would be to make sure that anything that you're training when it comes to machinery or tools is done correctly, that you've put the trainings in place. The last thing that you want is for a hand to go into something that it shouldn't, or for something to fall on a foot that shouldn't. So make sure that you've got all your trainings in place, and hear out your employees is the last one that I wanted to kind of send your way, is to speak to your employees, see what's going on, and actually find out what they want in terms of more improvements or changes in the particular workplace, and conduct regular reviews. It's the best way for you to have your ear to the ground and to see what's going on in your workplace. So what I will do is I will actually move on to a very, very exciting part, which is to do with how we can help you stay compliant. I'm so excited for this. I've got Tracy on the call. Tracy Black is the most amazing advisor and somebody that has a great expertise in both Australia and New Zealand. And I'm so excited for her to kick things off and to have a chat to you about how you can actually stay compliant using Employment Hero. And we're so excited to introduce a new service. So Tracy, if I can hand over to you, that will be fantastic. Let's see if this all works. Oh, we're all doing the same background, Tracy. I'm loving it.
We're doing the same background this morning. Good morning, everyone. As Sanam said, my name's Tracy Black. I head up the new service that we've got with Employment Hero, which is an advisory service for the New Zealand business. So as part of that service, we've got 4 key areas or 4 key parts of the service that we provide. The first one being an unlimited workplace advice line. So we have an on-demand access to our team of expert HR advisors. We've got some great advisors in the team ready to take your phone calls and emails. We pride ourselves on being able to provide guidance that is really clear, free of jargon, and just easy to understand, to get you able to deal with the things that come up in your business quickly and carefully. We have a compliance health check. So we undertake a health check around the compliance in your business, just to ensure that you're aware of your key obligations. And we'll go into a little bit more detail around what that entails in the next slide. We have a suite of policies and guides available. So as part of the service, you've got access to through the service. We've got a whole lot of documents available, templates, employment contracts, policies, letters, and guides. And then finally, if you are obviously a client of ours and you follow our advice from beginning to end, and you end up with a personal grievance, we offer an advocacy service. So that means up to mediation, that you would have our support around trying to defend any claim that was brought against you. So that's sort of the 4 key areas that the service entails. In terms of, I might just go on to the next slide. So in terms of the service and what it looks like, I really like to give a very clear visionary around what happens when you become a client of the service. So we've done it in a very easy to follow flow chart. So obviously when a client signs with us, which we love and we get very excited about, either myself or a member of my team will send out an email, which is just a welcome email introducing you to the service, providing you with the phone line, number and email address. You'll also be sent a link to a compliance questionnaire. So the compliance questionnaire, it asks you, sounds like a lot of very repetitive questions, but do you understand what annual leave, what you should be providing to your staff? Do you understand what good faith, the obligation to act in good faith means? It's just very simple, yes, no, unsure answers that you need to complete. Once that's completed, we would then assign an HR advisor to you, and then they're going to go through your audit, and they're going to provide you with really a traffic light response or guide. We provide like an audit document around those areas that really need the most urgent attention, whether you're compliant and things are looking good, or whether it's just a recommendation of something that we would look at that you need to really be addressing sometime into the future. So the audit document gives you some clear directions around if you don't understand what annual leave looks like, we're going to tell you what annual leave looks like. Very clear, jargon-free explanation around what you need to be across. And then obviously at the very bottom of my little flow chart there, you can see that while that compliance questionnaire is underway and that audit process, you get access obviously to the unlimited workplace advice through either the phone line or the email address. So yeah, that's the HR advisory service in a nutshell. We're very excited about it. As I said, I've got a great team working alongside me, and yeah, we're looking forward to working with all of you.
Oh, that's so exciting, Tracy. I can definitely vouch for the team. I have met them, I've spoken to them, and they are fully switched on. They love the New Zealand sector in terms of kind of upskilling and understanding and training and working with their clients. So I think it'll be absolutely amazing. And like I said, if you're dealing with any niggly issues, anything like that, this is the service for you. This is what you need, because it's going to be something where you can pick up the phone, you can give us a call, and you can, well, probably not me, Tracy's the one to go to. and then you can see, what you need help with, and we can go from there. And I have seen that compliance questionnaire, and it is definitely something that gets you thinking. And it's something where on the face of it, like Tracy said, might be like, oh yeah, no, and I do this. And then when you really peel back the layers, you start realizing, oh yeah, these are a few issues here. Do I actually know the mandatory clauses in the contract? I don't even know the mandatory clauses. So yeah, so these are all things that will come up. So what I wanted to do is actually hand it over to you guys, just to see what you're feeling about this kind of service or this particular thing in the space, because I wanted to see if this would be beneficial to you, beneficial to your business, and whether it's something that you would actually, whether you can actually see, if this is actually going to benefit your business, and if it's something that you might need on a day-to-day to contact somebody to give you some advice on how to kind of work through all these employment issues, and just setting up policies and having structure in the workplace, because it's always hard to start with compliance. I completely understand. All right, perfect. So what I will do is I will kick things off for the Q&A. I actually am struggling a little bit because I can't find, I now know where it is. It is on my other screen. Bear with me, everyone. I was trying to figure out where my Q&A box actually was. I have found it now. So I will go ahead and pop this up. Just bear with me. Okay. All right. So I can see, oh, great. I'm so glad that people have said that the Toast Martinborough was great. I would love to definitely see you all there if you were there again. And so, okay. Oh wow, so we don't have anything too crazy or too out there in terms of questions, which is great. I'll just see if I've got anything here. So do labor inspectorates conduct random audits? I saw one question come in. Sorry, I'm going to be now darting all over the screen, so bear with me. Yes, they do do random audits. They absolutely do this all the time. They come in and they check up on businesses. It doesn't have to be because they got a tip off or anything like that. That's what the question was gravitating towards, whether there's been any tip-offs or grievance claims or anything like that. No, they can just come in. I've seen the worst cases of businesses that absolutely didn't want this to happen to them, and they've kind of put their head in the sand, and the employers were just like, we don't have to worry about this. But then what ends up happening is you get slapped with fine after fine after fine, and I've had to see employers put up their houses and all of that stuff. So would never, ever, ever want you to go through that. So please make sure that you stay on the right side of compliance. And when we're looking at, let me just have a look. So with annual leave for casual workers, I specifically didn't see anything in the legislation or the Holidays Act relating to that. It will most likely be that 8%, that PAYG, but we'll see where things go and if there's any changes around that, but definitely nothing that we've seen at this stage. So I'll go on to the next one. So look, this is a question that came up, and I'm sure that we're going to get a few around this, and it's around the close downs, and that's why I really wanted to mention it in this webinar. I really do think that we're going to have a situation where people are going to be starting employment this year, and you're wondering whether you should pay them out the 8% or if they can take leave in advance or leave without pay. The ideal situation, according to the law, is that you need to pay them out 8% of their earnings for that year, or however many months they've been there. A lot of employers don't. So what they end up doing is they say that you can take leave in advance, which is anything that they've accrued up until that point. Now, to the person that asked this question, if you want to say to them, hey, look, we're going to give you leave without pay, I wouldn't recommend doing that because the law is very clear in giving them that 8% unless they're not entitled to any leave, or they've only been there for like a week or something like that. Then that's a different scenario. And that has happened. I think I've started one employment where I just started before Christmas. It was great up until I didn't get paid for that time. So yeah, that would be the situation. And then I had the same question that came up from somebody else. And in terms of the family violence and bereavement and all of that, the FBAPs, there was a question that came up around another accrual type of leave, or will the different leave types have different rights under there? So I definitely went through it on the slide. So there will be a lot of different ways that you can that you can calculate depending on the different types of leave, but generally the calculation has been very clear that it's going to be the greater of those two. So definitely check that out, and we we've done some information already in the past in terms of fact sheets and all of that. So we will definitely have that information available to you after the webinar. So you can definitely have a look at that. And sorry, I'm just trying to breeze through these. We definitely have them flowing in now. And I was here looking at our chat box thinking that there were no questions, but we have them all coming in now. So let me have a look and see. Yes, so there has been a question that's come in around sick leave entitlements for part-timers and casual employees. There has been a lot of discussion around pro-ratering the sick leave, but from what I've understood and the way that it's been spun in the media is that it has just been kind of mentioned in terms of the snippet that Brooke Van Velden, the minister, said that, that the structure would be. There hasn't been anything set in stone that I've seen where we can 100% say that this is exactly how it's prorated and this is what it's going to look like. So I would say watch the space. I'm promising you that as soon as we find out where this is all going, we will do a webinar. So definitely keep an eye out, subscribe to us, all of that good stuff, and we'll definitely let you know. And I got a question around what is an otherwise working day. So usually when you're trying to figure out if for example, a public holiday applies to an employee, you would want to know if their public holiday was, or if the day coming up was a day that they would have normally worked. So that's why otherwise working day is a language that's used. So in a normal scenario, if you had a 9-to-5 employee and you knew that they worked every Friday, then it would be very easy to say that, yes, that this is what what public holiday that they'll get because they work on a Friday, public holiday falls on a Friday. But where it gets a bit tricky is when the person works variable days, variable hours each week, like industries like hospitality, where they might not be working a Friday this week, but then the last 3 Fridays are the Fridays that they've worked. So that's usually how people look at otherwise working days to see if they would have normally come in on that day or a normal day that they would have worked. So what else do we have here? So yes, there was a question around whether fixed term contracts were being considered as part of the changes to annual leave and pay as you go and all of that. Yes, absolutely, they're being considered as well. And I can see alongside that there's another question around if fixed term contracts are considered as an employee or a contractor. Fixed term is definitely an employee. It's somebody that you're bringing on board to either fill in for someone else while they're on a period of leave, or maybe you're there to do a project or something like that. So that's where that would come up. Now, sorry, there's just breezing through them as quick as I can. So what else do we have here? So this is a good one. With the gateway test, what happens if an employee has specifically asked or requested to be employed as a contractor? Is the risk purely related to a contractor disputing the nature of their agreement? So if they had specifically requested the arrangement, then there should be no risk to them being a contractor. Look, at the moment, I would say that it's tricky to do that. With the new test, there may be room for or ability for an employer to say, hey, you were an employee, you were employed. Now I am engaging you as a contractor because this is what you've asked for. And it will probably make the situation look a lot better because once you've terminated that contract effectively, that employment contract or employment agreement, and they've now signed this document, you would assume, and I know assuming is not good, that the first port of call would be the gateway test. So there wouldn't be any looking at the relationship or anything like that. But we have to see what's going to come out about this. At the moment, we have 4 criteria to work with and nothing set in stone. So when that bill comes out, you'll definitely be hearing from us. I'll be working with our marketing team to get some content out there for you all. So in terms of other questions that have popped up, so sorry, I'm just reading through these. So there is a situation where someone is talking about contractors in patients and a clinical environment. That is very different when you're looking at the contractor space. They have their own set parameters and their own laws. Same thing with the real estate industry. They're called contractors, but then there is a lot of control and a very employee-like situation that comes up out of that. I would say just be a bit careful, but if they are somebody that is heavily controlled to the point where they're looking like an employee, then just make sure that in your sector that this is something that's commonly done and that it's not just an outlier in terms of what you're doing, because that's when it's all sector based when it comes to those specific industries. Not all of them, but certain ones. And in terms of, all right, let's see what else we got. So oh, this is a good one. This is not related to anything that we've discussed, but if an employee has a doctor's appointment without being sick, does that count as paid sick leave? I actually did an episode on this recently where somebody had asked me, what comes up in that scenario. And I actually did a post about this, and it would be, if it is honestly a situation where it is just a doctor's appointment, they are just going there to effectively do an eye test or a checkup or something, it's not because they're unfit for work or feeling unwell or anything like that, then that would be annual leave. It would only be sick leave if they are sick or injured, unfit for work. And that's the line that you can draw. That's what the legislation allows for. It's up to you as an employer to use whatever discretion that you'd like. So I'll just go on to a couple more. Bernie, how's it looking? Is it okay if I keep tracking along? You can drop me a message somewhere and and I'll make sure that I'll double check. So let me see. Some people have asked if the new calculations will, if when they come into effect, if they're going to be something that will work on our platform. Absolutely. We will be working on amending and fixing our platform. We have lovely people in our development team as well as in our product team that are completely across all the changes. And even when the fair pay agreements started, all the talk started, we were gearing up to have that all implemented when the legislation landed. But unfortunately, that didn't, well, maybe fortunately, it didn't go into place for some of those employers. Now, there's some random questions that have come in around fixed terms and working past end dates and things like that. I'll try to address those after the webinar and go from there. And in terms of any other questions, so there was an interesting one that just came through now. If there's any other transitions or anything where the law will allow for a period of time, look, I am going to be completely honest. I reckon what will happen, and what's very, very normal, is that they're probably going to release the draft bill. We're going to know that it's going to land, and then it will come into effect. Very rarely in New Zealand do we see anything like Australia, where we see a gradual shift and then there's an announcement and then it'll be, hey, in 6 months from now, this will impact you. We normally see an idea that the bill will be drafted, and then from there they'll progress and go through the houses and then finally bring the bill into legislation. So I think that that's the way that they're going to go. But this could be an anomaly. It could be a situation where they're really trying to help businesses get on track, and knowing how difficult the calculations are going to be, and for payroll people as well that are running payroll teams and platforms, it can be quite tricky there as well. So I'll just double check if Bernie is kicking me off, or if, okay, perfect. She said, I'm good to answer a few more, so don't worry. I'm still here, folks. Still getting things going. So I'll see what else we've got here. So observe public holidays. To be honest, I haven't heard anything about this. And normally what happens is that you have 1 of 2 days that will come up for a public holiday. It'll either be that the employee gets the day that the public holiday is observed, or the public holiday actually is kicked into place and is on that calendar day. So it will depend on if they're going to change anything around that. I personally haven't heard anything, but if there has been anything, we will definitely release more information around that. And let's see what else there is. All right, I might go through a couple more, and then I can see here I've got like almost 50, so there is a lot to get through, but I'll try to wrap these up as quickly as I can. Now, in terms of all right, let me just see. So will discretionary bonuses be gross earnings? Look, there is a chance that certain types of bonuses will not be forming part of that, but the new formula and the way that they have, or the new definition, was very clear in what they had said. I'll just go back to make sure that we've got the right wording on what they said around that. So all cash payments received except direct reimbursements for costs incurred is the definition that they've given right now, but we'll see what that actually means. And this is the problem. I think that this is the actual issue at the moment. It's the fact that we're in a space now where yes, the recommendations have come out, but is it actually what we need to know in terms of seeing how this applies to our business? Probably not at this stage. We've got general ideas of what the calculations will look like, but until we really see a draft bill, until we see something really broken down, very clear and specific to all businesses across New Zealand, it'll be very hard to pinpoint and say that this is exactly what they're going to bring into place. And at the moment, that's why I see so much misinformation or conflicting information online. It's because no one really knows what's going on. So I will wrap up soon. I got the message from Bernie. I hear you loud and clear, Bernie. And I'll just go through one more. Let's see what we've got. Some of these are lengthy, sorry. So I thought, let's see. Okay. So again, I got another question in here around broadening bereavement leave, and will there be a cap on limitation or definition of excessive? How will we identify and address people who aren't genuine? I actually did a whole entire episode on this recently. It is a tricky area. That is the curly side of bereavement leave that nobody really wants to talk about. And that's the reality, is that some people, just like with sick leave, might not be genuine with their bereavement leave. But unlike sick leave, this is a lot trickier area to navigate. You are dealing with somebody that potentially has had a bereavement, and your first port of call shouldn't be to doubt that bereavement. So definitely I would recommend checking that out. But generally what you would do is have parameters in place. So making sure that you're very clear on your leave policies and what needs to be done in that respect, and making sure that you've covered all of that off in a policy. And if push comes to shove, that you're treating all employees the same if you're requesting for proof of bereavement. So that is, but like I said, tricky area. And this is exactly why Tracy's team is there, is to handle those kinds of tricky questions, because it's very easy to run off and do these processes, and all of a sudden the employee kicks up a fuss, and now you're kind of dealing with the backlash of that. So I will get through as much of the other questions that are there as possible after the webinar. Bernie, I will be wrapping up now, so no worries. Let me make sure that I go through to the end so that I can pull up our details for you. So you've got Tracy's details there. The lovely Tracy is going to be the most amazing asset to your business, I can definitely tell you. And in terms of kind of where we're at the moment, look, we're wrapping things up for the year. The legislation is not clear cut at the moment. We know that somewhere along the line, there's going to be all of these changes coming out. They're saying 2025. They're saying a bill for the Holidays Act will be drafted by the end of the year. Let's have a look. Let's see what's going on. But I'm so glad that you were all here for this particular webinar and for this call. It makes me feel so good to know that you are all ahead of the curve when it comes to your compliance. So I'm really excited and proud of you all for that. Pat on the back. Now, at the end of this webinar, a survey will pop up. So absolutely, please engage in the survey. I always love to get feedback to see where we can tweak things, change things around. Maybe you might not want me, might want Tracy next time we do one. And if that's the case, it's fine. I won't take it to heart, I promise. Maybe a little. And in terms of the webinar, it has been recorded, so we will be sending out a recording to you all. If you missed any parts at all in the webinar, then please make sure that you take some time to go back and have a look. We'll be sending out post webinar materials as well, if there's any fact sheets or any links or any information relating to the actual webinar or any information we discussed. So don't worry, you're fully covered. Everything's all sorted. I just want to say a massive thank you to everyone. Thank you so much for being here and for tuning in. I hope you have a lovely and wonderful rest of the year, a lovely break if you are doing a break as well for you and your teams. And just thank you so much. Have a great day, everyone.